Hi, and welcome back to The Local Perspective. I'm Jerry Deschane. Local Perspective is a League of Wisconsin Municipalities show about issues of interest, but I got to tell you, when we get done with this Geek Fest today, you're going to want this woman's job. Guaranteed. If you are watching this show, what Lisa Soronen does for a living, you're going to say, oh man, come on, I want to do that. Lisa, good morning and welcome. Thank you for joining us.
Thank you for having me.
You're the executive director of the State and Local Legal Center. And the way I interpret that is you speak to the U.S. Supreme Court on behalf of every city, village, state, county in Wisconsin.
Exactly. There's only one.
That's all you do.
That's all I do.
That little
job.
job.
That's all I do, but it's a big job in some ways. So the only way to influence the Supreme Court, other than to have a justice as a neighbor or something like that, is to write amicus curiae or merits briefs, as the case may be, before the United States Supreme Court. So the court is going to take about 6 or 7 cases a term where a city is a named party. Then it's going to take twice or 3 times as many where a city is somehow affected. So my organization, the State and Local Legal Center, files amicus briefs to the Supreme Court saying basically, court, this is how whatever you decide will impact all cities, all villages, all towns. So I'm filing somewhere between 8 and 12 briefs a year, just depending on what the court has accepted on its docket, on all kinds of issues. Anything that could affect a city that you could imagine that the Supreme Court would be interested in, I'm filing a brief on that topic. From there's a land use case out of Wisconsin actually last term, police shootings, free speech, First Amendment, those kind of things. Anything you can imagine that affects cities, I'm filing a brief saying this is the perspective, this is the way the court needs to think about how all cities might be impacted.
I'm just so jealous. It's like I'm not even an attorney and I want to do that. Yeah. I've seen this on TV, it's cool.
It is really a remarkable job. I don't think most people every single day of their lives are thankful for their job they have. I won the career lottery. And another interesting thing I should tell you, being that this is for Wisconsin, is that most people may not know this, but the sort of #1 Supreme Court lawyer right now, he's considered to be the John Roberts of this generation. He's argued almost 100 cases before the Supreme Court. His name is Paul Clement, and he is from the northern Milwaukee area. So when I started this job, I was nervous to be interacting with all these fancy lawyers. You know, I was just a
And you're a Midwesterner, right?
Yeah, I was just a small town girl from Wisconsin. So I remember calling my husband and saying, I've got to reach out to this Paul Clement guy who's like a superstar. I don't know if I can really do it. And I remember him calling me and saying, you know, he's from Wisconsin. And I was like, oh, we're going to be fine. And we have been fast friends after that. And despite, I guess what's interesting too is despite the fact that this guy is such a prominent lawyer and such an important person, he's routinely representing state and local governments in the Supreme Court. There was a case actually out of Wisconsin, a jail case called Kingsley, where he was the lawyer who represented the jail. So Wisconsin has a good history, I think, of being involved in the Supreme Court and producing great lawyers.
I was about to say, do we have a good history of getting in trouble? Is that what you're saying?
That's certainly another way of looking at it.
Well, how did you get there? I mean, you work in Washington, D.C., you do this incredible, what we would call high-profile job. I've heard you speak numerous times over the years. The encyclopedia of knowledge in your head's incredible. How'd you get there?
So, you know, this is the point in the conversation where I think about the audience and how this is a great time to pull out your college and high school students to watch what I have to say. Because this is the best career advice that I could give anyone, and it's what really affected me and I think made a big difference. It's not what you know, it's who you know. And that is a part of the version of the story of how I got here. But the longer version of the story is that I went to Wisconsin for law school, and I clerked for the Wisconsin Court of Appeals, and I got a job. My first job was at the Wisconsin Association of School Boards after clerking, and I had never heard of school law. Obviously I knew what school districts did, and I did collective bargaining for a while. I disliked it because I felt like it was fighting over pennies and dimes for teachers who I perceived as largely underpaid. And I was kind of anxious to get out of collective bargaining, and I had a friend who was moving to the Washington, D.C. area who saw a job at the National School Boards Association. She gave the ad to me and said, apply for this. And I did apply, and ironically, I didn't get the job. The person who was to hire me told my reference, I can't decide between this Lisa woman and this other guy, Tom. And so ultimately, Tom was hired and not me. But someone quit a week later. And so I was the second choice, so she ended up hiring me. But getting to that, it's not what you know, it's who you know. The person that hired me was Julie Underwood, who had been a professor at the University of Wisconsin and subsequent to working at the National School Boards Association had been a long-term dean for the College of Education. So I'm sure she saw my name and Wisconsin on my resume and was curious about me. Her boyfriend at the time also was a labor lawyer, and he wanted someone who had a labor background. That's who he encouraged her to hire. So that was kind of how I got that job. But how did I get the job at the State and Local Legal Center? Well, I knew the guy that had my job previously, because if you think about it, I was doing all the work for school districts along with my colleagues at the National School Boards Association. And who was handling all other state and local government Supreme Court work was the State and Local Legal Center. So the guy that worked there, I always wanted to invite him to lunch and say, how can I have your job? But I just felt like it was
that's really kind of an awkward conversation.
It was too tactless. I just couldn't figure out how I could really pull that off.
You know, how you feeling these? You planning?
Yeah, are you planning on retiring anytime soon? It just seemed too tacky to me. Well, then one of my colleagues at the National School Boards Association had gone to the National Governors Association, which is one of these groups I file amicus briefs on behalf of. And when I noticed there was a vacancy, I told her about it. And she marched into her boss's office and said, I have the woman for this job, and you are going to see to it that she gets hired.
Wow.
And yes.
How do I get a friend like that?
Yes, I mean, this is the kind of person you want advocating for you. And on a sort of, I don't know if it's a coincidence, but at the National School Boards Association, I had filed an amicus brief that I'd partially written on an employment topic. And I had said to one of my interns, look, like, we need some sort of more meat in this brief. We need some theory of the case. Can you find something somewhere? And he or she, I can't even remember which it was, brought back a law review article and said, this is a theory. I said, let's put it in our brief. And Justice Alito, in a concurring opinion, so not the majority opinion, so it didn't sway the whole court, but in a concurring opinion, had talked about that theory. He didn't cite to our brief, but I felt like, oh my gosh, this is it. So I went to the interview and I said, look, the Supreme Court justices listen to me. I am the person you need to hire. But I think more significantly, my predecessor had been an introvert, and I think they really wanted an extrovert, someone who would sort of bring the court to life and go out into the world and talk about what the court's significance is. And the truth is, as much as I love the briefs and going to the oral arguments and being a part of the Supreme Court, my real passion is to try to convince people that the law matters, and that the Supreme Court matters, and that it affects people, their everyday lives and their careers as well. And so for me, the job evolved from being nervous about just interacting in the Supreme Court space to feeling like I'm sort of an ambassador for the court who tries to tell the court's story as much as I can to my constituency when I'm given the opportunity, like this one.
My guest is a former UW-Madison law student, Lisa Soronen, a Wisconsinite, a Yooper at least in some part of her past. But she's the executive director of the State and Local Legal Center in Washington, D.C., an advocate for local government, state government before the court. For those who are watching, and I know that most of them are policy nerds, but let's kind of break this down a little more basically. You're not in the business of suing on behalf of local government, are you?
No. So for a case to get to the Supreme Court, it typically takes about 10 years. So that means generally someone has sued a local government, and it has proceeded through a variety of courts. Oftentimes, if it's a federal case, it would be a federal district court. In Madison, or in Wisconsin, there are two. There's an Eastern District of Wisconsin, the Western District of Wisconsin. Then the case would go up on appeal to the 7th Circuit. Wisconsin, Illinois, and Indiana are in the 7th Circuit. Then, if one of the parties asks the Supreme Court to take the case, the Supreme Court can decide to get involved or not. About 10,000 petitions are filed a year to the Supreme Court.
Those are requests for them to take a case. 10,000
parties ask the Supreme Court to get involved in a case. But the Supreme Court rarely gets involved. It decides 60 to 70 cases a year. And The court has two jobs, and these are jobs that it has decided for itself in its own rules. The first job the Supreme Court has is to resolve circuit splits. So there's about 13 federal circuits. Like I said, Wisconsin is in the 7th Circuit. And it's often the case that federal circuits will decide the same issues differently. And the court sort of lays down the law once and for all and says, nope, you guys have disagreed, now we're going to give you the answer. The court's doing that probably 60 or 70% of the time. A lot of the court's docket is actually very boring because they're deciding very simple and mundane circuit splits. Then, the part that makes the news, typically in June, is when the Supreme Court decides those big cases where there may not be a circuit split. Well, the court's other job is to decide major questions of federal law. If a federal statute is ever declared unconstitutional, the Affordable Care Act is a great example of this, or even unlawful, the court is going to get involved in a dispute that big. Same-sex marriage is another great example of sort of both of these theories. The Supreme Court didn't decide whether or not same-sex marriage was required by the Constitution until there was a circuit split. I think 5, 6, 7 circuits had gone one way. It said there is a constitutional right, and the court refused to get involved. Then when finally one circuit said, nope, we don't think there's a right, then the court got involved. But almost invariably, at some point, the court would have decided that question because it was a huge question of federal constitutional law. So, let me get back to your question, which was...
I was going to bring you back around to it, but I was just having too much fun listening to you.
Does the state and local legal center actually get involved in people suing people? So no, it's when the Supreme Court accepts a case and decides to get involved in a dispute, then what we do, it's kind of like we get involved at the last minute and say, okay, court, now that you've gotten this case, here how all cities will be impacted by this particular issue.
So you're like the nosy neighbor that sticks your nose into the argument.
Yeah, and
late
gets all
in the
the credit. Like I get all the credit by being involved in all these Supreme Court cases, even though I sometimes or really always show up at the 11th hour.
Because I'm sure there are other organizations that do similar things on behalf of business or labor or environmental interests. How does the court see people like you? Do they think you're a pest? I mean, where do they...
That's such a great question, because as a technical matter, the Supreme Court should not care one iota what the state local legal center says or any other interest group says. And the reason is because as we think about the law, and as a number of Supreme Court justices, namely the late Justice Scalia, made us think, was that the law should be decided by looking at the black letter, reading the statute, deciding what it means by the text, and not looking into all the reasons. But the reality is judges are human beings. They read the newspaper, they live regular lives, and they want to make sure that they don't do anything that really messes things up. These justices are generalists. One day they're dealing with patents, one day they're dealing with bankruptcy, the next day they're dealing with a takings case, then they're dealing with the First Amendment. They can't possibly know everything they need to know to decide the cases. So they welcome these amicus briefs for those reasons. One, they can't possibly know everything, and the amicus briefs provide a bigger picture of what the law means, what it does, how it affects particular organizations. And then two, they care about the real world impacts. The justices are very self-conscious of the fact, I think, that they tend to be older. The typical age of a Supreme Court justice is about 70. They're majority white, they're majority Catholic, and they're majority East Coast. And they're worried that they're doing things that impact people out in the world, like farmers, for example, that they would have no personal knowledge or personal experience with. But I do think the court cares about some amici more than others. And studies and research have indicated as much. And state and local government are a group that the court particularly cares about because, well, if for no other reason, then I would say 60 to 70% of the docket has some impact on state and local government. If abortion is your issue, or animal rights are your issue, you're going to appear before the Supreme Court once or twice a decade. So the Supreme Court doesn't get any chance to know you. Your perspective is going to be very sort of limited, and you have this policy issue that you want to further. State and local governments, our only policy issue is furthering a well-functioning government, a well-functioning, cost-efficient government. We don't have some sort of shtick or some sort of angle that is narrow or niche preachy. We care, just about government being functional, sensible, reliable, efficient, and effective. And that's a message that resonates with the court.
Do you ever get pushed? You represent nonpartisan elected officials, partisan elected officials. Do you ever feel pushed, pulled, tugged to the political left or the political right? Or does that really truly not come into play with you?
So that is also another great question. What is very interesting about my work is that I have a couple different answers for it. To the extent that I work on cases that exclusively affect the states, my state groups are terribly politically sensitive, because who are in my state groups but governors, people that run as a particular political party? I always joke, and it's true, if I'm involved in a state case, no one has ever heard of it. I probably haven't heard of the legal issue until it comes before me. Local governments, it's very different. The local government members, even if they run as Democrats or Republicans, don't necessarily identify as strongly with those issues. So I don't get much pushback on issues that deal with local government. And what's remarkable about the job, and I think in some ways extraordinary, is that I'm going to file amicus briefs in Supreme Court cases all over the political spectrum. So qualified immunity, those are cases that typically involve police shootings. We are the only organization out there that defends police officers in these shooting cases. Why? Well, because it's the state and local governments that pay the bills. So that would be considered, I guess, very, very conservative. Now, this last term, if you followed the Supreme Court at all, you probably heard about the cake case. This is a case involving two men who are getting married in Colorado who wanted a wedding cake. And the cake shop owner said, I won't make you a wedding cake because it violates my religious beliefs. I don't believe that the two of you should be getting married, essentially. And Colorado has a statute that's a public accommodation statute that says you can't discriminate against people, and it includes sexual orientation. So Colorado said, nope, you can't discriminate against these individuals, you have to make the cake. Well, that case went to the Supreme Court, and we filed an amicus brief in favor of Colorado's statute, in favor of these two men. And the reason is because tons of cities, hundreds, in the United States also have these ordinances, and they don't want exceptions created because they don't want to administer those exceptions. An exception for you, an exception for you, it gets all sort of complicated. So and just two more examples that are kind of interesting. We are the only organization, again, that says we want a smaller, more narrow First Amendment. If you think about it, the only party you can sue for violating your First Amendment rights are the government. So we're frequently, and the First Amendment isn't necessarily conservative or liberal. It kind of depends on the issue. And then another issue that I think, too, falls on the ideological spectrum on the left is the property rights issues. The takings cases, we're supporting government. We're supporting the public interest. So we're more on the left. So the politics come into play in these cases. There's no question about it. But oftentimes, we're able to get involved in the cases regardless, because what's more important than the politics are the outcomes for state and local government, for them to be autonomous, effective, reliable, efficient, those sort of things. Those are the values we're promoting in our briefs, not liberal or conservative. So we're able to sort of position ourselves as above the fray. How much the court buys that, it's hard to say, but if the court pays any attention to what we're doing, they have to recognize that this is truly a nonpartisan organization that files all over the ideological spectrum.
So I've got to ask you, Lisa, what was your over-the-fence center field home run? What's the proudest moment you had?
My proudest moment. So the trouble with explaining it is a bit complicated to explain.
All right. But try to keep it.
I'll try to keep it as simple as I can. And it's hard for me because I feel like so connected to this story. But many of you probably heard or seen on the internet when you've been shopping that now you're being required by internet vendors to collect sales and use tax, or to pay your sales, use, and tax through that online vendor. So for decades, the Supreme Court had said if you're an out-of-state retailer, you didn't have to collect sales or use tax, which was no big deal in the 60s when the court had come to this conclusion. But in the 2000s and prior, it was a huge deal when Amazon blew up and all these online vendors were saying, hey, we don't have a warehouse in Chicago or in Wisconsin, we've got one in Illinois, so we're not going to collect the sales tax. And the State and Local Legal Center a couple years ago filed an amicus brief in a case kind of related to this topic, but kind of not, saying to the Supreme Court, hey, would you reconsider that precedent that said out-of-state retailers can't be required to collect sales and use tax? And when we filed this brief, I kind of thought of it as sort of a throwaway brief, in the sense, like I said, that the court wasn't contemplating should we overturn this precedent or not. They were contemplating a different question. So we wrote this brief, and actually when the case came down, I didn't even look at Justice Kennedy's concurring opinion until later in the afternoon. So Justice Kennedy, who you should know is the most, I still say is,
retired.
Was the most powerful justice on the Supreme Court, wrote an opinion saying, I really think we should overturn this precedent. I was on the court in 1992 when I affirmed it. I see the world's changed. We need to do something about this. And he said, legal system, bring us a case to overturn this precedent. And it was that opinion that led to South Dakota passing a law that violated this old Supreme Court precedent, and then the Supreme Court accepting the case, South Dakota versus Wayfair this term, and overturning that old precedent. Now, I always have to be careful when I tell this story because Justice Kennedy, in his opinion, did not cite to the state and local legal center's brief. But remember, the brief is off topic, and he did cite to a number, or he included a number of citations that I had in the brief. So I don't want to take too much credit for it, but it was very clear that he. But I know what he was thinking. But it was a really tense thing when it happened because, like I said, Justice Kennedy at the time, and for 12 years, had been the swing justice on the court. So in all the big cases, and this was bound to be a big case, the court was typically been 5-4. And no other justices joined that opinion saying, hey, let's overturn this case. Maybe because the opinion, the case, like I said, didn't really bring up this issue. But there was a lot of tenseness, of feeling like if other justices really wanted to do this, why wouldn't they have signed up for this? But it was the most powerful justice. I mean, Justice Kennedy
was powerful because he's the guy that can create a majority. He's the swing vote, if you will.
Yeah, I mean, what I would say about Justice Kennedy is if you look at his 12-year career, he was arguably the second most powerful man in the United States. And the first most powerful man would have been the president, which would have been various presidents during the time. So in some ways, he would have been maybe the fourth most powerful. Just so think about the last 12 years and what the Supreme Court did. Said for the first time that you have a right to a gun in your home. That had not been clear until, in the last decade. The Citizens United decision on political contributions. Huge decision. Many Americans are still angry about it. And many Americans are happy about it. But huge, huge decision.
But it's changed the way we do politics.
Absolutely. The Guantanamo Bay cases, no impact on state and local government, but huge cases for, how our country was going to treat criminals. Justice Kennedy was very, very important in cutting back on the death penalty. Not an issue in Wisconsin, but a big issue in the United States. Same-sex marriage. Justice Kennedy was a champion of gay rights, and on day one on the court, he didn't start out that way. That was a way that I think he evolved. Bush versus Gore, he was on the court at that time as well, but the Affordable Care Act, it was ultimately Roberts that saved the Affordable Care Act the first time. The second time, Justice Kennedy voted to keep the Affordable Care Act or not say it was unlawful. So he was a really important man. If he wanted something to happen, it would happen. The question was, would a case get to the court for them to take it? But if he wanted, he got it. Okay.
I want to pause here. One of the reasons we're talking to Lisa Soronen, the executive director of the state and local legal section, in the September issue of the Municipality magazine, Lisa kind of summarizes the key cases from a municipal perspective, what the court did in the last term. And there was a lot of really powerful, ground-changing things going on. Don't have time to cover all of that, but Lisa, early when I was thinking of questions I was going to ask you, one of them was, are you getting bored? But that's a dumb question. When you write your book about the court,
yes,
which chapter is going to be the most fun to write?
Oh, that is an easy question for me. The most fun chapter for me to write would be on Justice Kagan.
Not Justice Kennedy.
No, Justice Kagan. So, and I will say that I'll start with this caveat. I do not count on Justice Kagan's vote for many state and local legal center briefs and issues. So
She's not a local government.
She's not, and she's a liberal, and having moderate justices is the ideal for me, but she's a little further on the liberal spectrum. The reason why I would count her, or why I would write my chapter about her, is this. So if you ask your average American to name the female Supreme Court justices, you're more likely to get the name Judge Judy than Justice Kagan. But Justice Kagan is, as you know, I have 5.5-year-old daughters, and the Supreme Court allows children age 7 and up. I don't think my daughters will be mature enough at 7, but when they're 9 or 10, I'm going to take them to the Supreme Court and show them Justice Kagan. So Justice Kagan comes to the arguments completely prepared. She asks the really hard question, the question at the heart of the case. If you are not ready, if you do not truly understand what is at stake in your case, she won't embarrass you because she's too kind to do that. But she knows how to get to what's really going on in your case. She's tactful, she's funny, she's relentless, she's ironic, she's calm, cool, and collected. She is just this remarkable woman who just carries herself with such dignity and such intelligence. I think she is one of America's most famous, unappreciated people. I want the world to know about Justice Kagan. I want the world to know how smart she is, how thoughtful she is, and how, even if she votes liberal most of the time, she has got an eye for the heart of the matter like no one I've ever seen.
Frankly, as you were talking about that, I thought you're describing yourself.
I don't stand in the shadow of Justice Kagan.
We're down to just a couple of minutes, and I knew this time would go too fast. Real quick, what are we looking at from a municipal perspective from the court next session?
So it's pretty typical at this point that the court has not accepted too many super exciting cases. They've accepted about half of the cases for their term, and their term starts October 1st. Probably the biggest case of interest to local governments at this point is a case called Nick versus the Township of Scott. It involves cemeteries, which sort of makes it more interesting. Unfortunately, the facts of the case are possibly more interesting than the law. The facts of the case are this family owned this plot of land for years, and they divided it up in the 50s, and the part of the plot of land they sold had their relatives on it, their deceased relatives.
They sold their relatives?
Yes, they sold their relatives.
Okay.
And the property owner for a long time had allowed them to visit, and then I heard, I don't know, that she went through a nasty divorce and suddenly wouldn't allow them to visit any longer. So the city adopted an ordinance saying that if there's a cemetery, you can visit at any time, and city officials can come to your property at any point and determine whether or not there's a cemetery. You can imagine that this went over with her like a lead balloon. And so she sued for a taking, and that's not the issue before the Supreme Court, whether there was a taking. I think probably pretty clearly there was a taking. The issue was whether or not this case should be heard in federal or state court. And this may not sound like that big of a deal, but in some context, for 30 years, these cases have been heard in state court. State courts have, or state legislatures have come up with all sorts of procedures to hear these cases because the Supreme Court said these cases should be heard in state court. Also, state court judges, more likely to know the area, more likely to know state property law, more likely to care about the area. Like if you go to federal court, your judge could be from Indiana and not know anything about Devil's Lake or whatever. So, but there's something else that's going on in this case that's really interesting, and is part of the reason why I want to talk about it. And that is that the Supreme Court has historically, especially in the Roberts years, which have been the last 12 or so years, has hardly ever turned over any precedent. That is not what the Supreme Court does. Last term they overturned 2 precedent, and in this case they're poised to overturn 2 precedent as well. And so you might be wondering, like, what's going on? So this is what's going on. Justice Scalia, who really kind of favored landowners rather than the government in these cases, liked this Williamson County rule where the cases went to state court. As soon as he left the court and Justice Gorsuch joined the court, the property rights community was like, this is our chance, let's get this overturned. And I think that's what's going on.
Okay, so big property rights case coming up.
Yep.
I am so bummed. We are out of time. Lisa, thank you so much for coming back to Wisconsin, being with us. Lisa Soronen, the Executive Director of the State and Local Legal Center, which is supported by the League of Municipalities and all other leagues, other states. She is our voice before the U.S. Supreme Court. Thank you very much for being here. I'm Jerry Deschane. This has been The Local Perspective.